Good morning. For those of you that don't know me, I'm Myra Thompson with Administrators Advisory Group. We are a small to mid-sized group brokerage providing HR solutions to clients across 10 states nationally. Thanks for joining us for our annual employment law update. In a minute, I'll hand the presentation over to Keith Hammond of the Hammond Law Group to walk us through some of the recent changes under the new administration. I'll run over some quick housekeeping. So today's presentation will be recorded. We'll mute all participants to avoid any background noise. If for some reason you're not showing up muted or you've dialed in, if you'll go ahead and hit mute on your phone, we'd appreciate it. If you have any questions that you haven't had a chance to send in prior to the presentation, you may use the chat option to do that. I appreciate everyone working with us over the past year. We've had to throw out a lot of what we knew to be true and talk on decisions on a case-by-case basis. We recently had the outbreak period requiring us to share information on extended deadlines with our current and former employees in order to stay in compliance with ERISA. We've had many laws put into effect that have impacted all of your responsibilities and work environment. AAG will continue to work closely with you over the next several months and years as we are anticipating changes towards a more pro-employee stance. Based on the confirmation of Marty Walsh to be our Secretary of Labor, Keith will get more into those changes that we expect. Additionally, with the nomination of Douglas Parker to lead OSHA. Next month, we'll cover more of his background and those expected changes. We're going to be required to tighten down on multiple policies to accomplish the coming changes. Currently, the COBRA subsidy seems to have the greatest attention. This new law allows employees that were involuntarily terminated to elect COBRA and have it covered at 100% from April 1st through September 30th. So this will cover anyone terminated back to November of 2019 through September of this year. So much like Families First, this is an employer-first government subsidized program. On a brighter note, Patty will be out in June again for our courtesy I-9 review. There are a few new requirements specific to Florida. Keith will touch on those and Patty will cover in more detail when she's on site. She'll cover which forms to use, how to correct an I-9, some common mistakes, some remote hiring challenges, as well as the new E-Verify and independent contractor requirement. So I'll now hand the presentation over to Keith, I think.
Thank you, and I'm going to try to share my screen so that I can control it rather than have Myra doing that. Does everybody see the new administration, new workplace laws? Hopefully.
Yes.
Great. Okay. Well, first, before we begin, let me introduce myself to those who don't know me, which is probably not too many of you on this this meeting today. My name is Keith Hammond. I am with Hammond Law Center. I'm a management side employment law attorney and have had the pleasure of working with many of you in the past. I've worked with Myra for many years, and once a year we like to put on this employment law update. Which is in lieu of the normal face-to-face time that you have with AAG when they come out on a monthly basis. For those who don't know me, I'm a pretty informal guy. I don't mind answering questions as they arise. You don't have to wait until the end. Feel free to use the chat function. And if I don't see it, Luann might clue me in if there's a question pending. And before we move on to different sections, I'll try to just ask the group if there are any questions that I can address while we're on the topic. So when we last met, back in April of last year, we were in literally a different world than we had been in even a month before. The coronavirus pandemic was taking hold. You know, I reviewed the timeline that we discussed the last time we met, and golly, things were happening fast and furious. You know, there was more or less the understanding that this was a big deal around mid-March. It wasn't until later in March that new laws were starting to be passed and stay-at-home orders were being issued, first on a city-by-city and county-by-county basis before finally Florida issued a statewide stay-at-home order in early April. Workplace laws evolved rapidly during this period, March and April of 2020, as well as throughout the summer. And even now, as we'll discuss today, there are new laws that have been coming out. President Biden had a press conference yesterday to tout one of them, in fact, that we'll talk about. And pretty much we can break down what the evolution of workplace laws entailed into two categories. One was the implementation of new laws, basically laws that provided for time off to deal with various COVID-19 related issues, as well as money for businesses that were impacted or that the government thought would be severely impacted by COVID-19 pandemic, mainly in the form of loans that maybe didn't have to be paid back, but also in the form of tax credits for paid sick leave that was mandated by the FFCRA, the Families First Coronavirus Response Act. The other category of the evolution of workplace laws was how the COVID-19 pandemic translated to traditional employment law coverage like the Americans with Disabilities Act, or GINA, the Genetic Information Non-Disclosure or Non-Discrimination Act. And what we're dealing with still is the evolution of guidance from the EEOC on what you can and cannot do, guidance from the CDC on when you should take somebody and have them take a timeout because they've tested positive or they've been in close contact. We've even seen an evolution of what the definition of close contact is since last March, last April. We continue to do so. Today's goal is to get everybody up to speed on what the current guidance is, to let you know what the new workplace laws are, particularly the extension of the FFCRA, as well as some non-COVID-19 related employment law updates. So here's where we are today as compared to a year ago. A year ago, we were 3 years into the Trump administration. Now we're about 3 months into the Joe Biden administration. As everybody who's attended one of these updates in the past knows, when there's a changeover in administration, usually you can count on a sea change in how employment laws are enacted, how they're regulated, and how they're enforced. And I would say that's probably going to be the case again today. We'll also talk somewhat about, hopefully, a beginning of a return to normalcy. Now that vaccines are widely available, more and more employees are being vaccinated, more and more employers are returning everybody to the office rather than having them work remotely. I've heard many employers say that they have an early May time frame for bringing people back into the office. So hopefully this information is very timely if you are one of those employers that's about to start bringing people back. So here's specifically what we're going to cover today. We're going to talk about the extension of the FFCRA through September 30th of 2021 and what that entails. There are actually some changes to the FFCRA in addition to the voluntary extension of it through the fall of this year. We will discuss somewhat briefly, but just to give you some information, PPP, of course, the infamous loans that were designed to help pay payroll and to cover rent and utility expenses, and which some individuals did not use for those purposes and got into big trouble. But there has been an approval of round 2 funding, meaning if you received a PP loan last year, under certain circumstances, you might be eligible for another loan. I was talking to Myra earlier about how the cutting edge issue over the last couple of weeks has been pertaining to vaccination issues. Can you require your employees to be vaccinated? And on the other end of the spectrum, can you incentivize your employees to be vaccinated? Recently, you may have heard, I believe it was last week, that Florida passed and the governor signed into law a COVID-19 business immunity law. We'll go over what you need to do to take advantage of that particular law. That's not simply a return to the wild, wild west where you can tell employees don't wear masks anymore and don't worry about social distancing. It's actually quite the opposite of that. But it is a boon to employers in Florida, particularly those that are at high risk of lawsuits, where it's alleged that because of your conduct, employer or business owner, your customers, your employees, your vendors ended up contracting COVID-19. We'll also talk about some non-COVID related employment laws and look into the crystal ball with President Biden's employment law agenda so that everybody knows what is likely coming down the proverbial pike. But first, let's start with COVID-19's continuing impact on workplace laws. As I mentioned, the FFCRA has been extended. It's actually been extended twice. Just to give you a very brief history of that law. It was enacted back in March of 2020, went into effect in early April. It provided for paid sick leave, as well as an expansion of the Family and Medical Leave Act. In fact, under the FFCRA, this type of FMLA leave was paid. There was also a dollar-for-dollar reimbursement to employers in the form of tax rebates or tax credits. In fact, if you were small enough of an employer that you couldn't afford to pay the paid sick leave or paid FMLA leave, there were forms that you could fill out with the IRS that would allow the government to actually float you the money that then you would, of course, return or whatever, claim as a tax credit when you filed your 941. Originally, the sunset date on the FFCRA was December 31st, 2020. In late December, though, Congress and at the time President Trump passed the CAA, the Consolidated Appropriations Act, which extended the FFCRA through March 31st, but only on a voluntary basis, meaning you, the employer, got to choose whether or not you wanted to continue providing that emergency paid sick leave. Remember, it's the 2 weeks or 10 days of paid time off, or the expanded FMLA to your employees. You didn't have to do so. But if you did choose to do so, the benefit to you was that you would again be able to claim the dollar-for-dollar tax credit when you filed your 941 forms. In March of this year, Congress and now President Biden passed the American Rescue Plan Act, or ARPA, which, among other things, extended the FFCRA again through September 30th, 2021. This extension of the FFCRA, however, was slightly different than the extension back in December. This time around, the FFCRA now has 3 additional qualifying reasons to take the paid sick leave. Number 1, an employee can take paid sick leave if they're seeking or awaiting the results of a diagnostic test for or a medical diagnosis of, but be careful because my reading of the statute requires some sort of diagnostic test for a medical diagnosis of COVID-19 and after an exposure to COVID-19 or test or diagnosis at the employer's request. So in other words, if somebody says, hey, I'm not coming to work today because I had a close contact, I'm going out for a COVID-19 test, they can take paid sick leave if you voluntarily have decided you're going to take the tax credits for that. Or if somebody shows up hacking and coughing and you decide you're going to send them out for a test, they're eligible for paid sick leave in that circumstance too. Not only for the time they spend taking the test, but also waiting at home to get the results of those. And I know for some of the better tests, it can take 24 hours or maybe even more to get the test results. It might take you some time just to find out where there is a testing center. Within the last couple of weeks, I've observed that some testing centers have gone to full-time vaccination sites or they've moved around, they're now mobile. So depending on exactly where you are in the state, it might take a day to figure out where to even go. That time can be paid sick leave. Number 2, if an employee is obtaining immunization related to COVID-19, their time away from work can count as paid sick leave. You as the employer can get a dollar-for-dollar tax credit or rebate for any paid sick leave that you pay for that circumstance. Many of you have asked, does that mean that the time they spend traveling or waiting in line to get a COVID vaccination counts? And the answer is yes, probably it does. Having heard President Biden's speech yesterday, I am more convinced that yes, in fact, once the IRS finally comes out with regulations sometime in the future on this, that yes, absolutely, the time spent waiting in line or traveling to get a vaccination will count. You can provide paid sick leave, you'll get the rebate for that. And then finally, this is the big one that the President Biden spoke about at length yesterday, is you may provide paid sick leave and get the tax credit for time spent by an employee recovering from any COVID-19 vaccination. It's been pretty well publicized that many individuals have side effects after receiving one or both immunization shots, and many times that requires the employee miss work. Normally, from what I understand, it's only for about a day or two, but there are cases where people remain ill for even weeks at a time. That time off can be given under the FFCRA, and you'll get a tax credit or rebate for it. So these three new qualifying reasons are in addition to the original 6. Let me go over them, not to bore you, but because it will be very relevant when we see the next slide or two. The original 6 reasons that an employee could qualify for paid sick leave included, number 1, the employee being subject to a federal, state, or local quarantine or isolation order related to COVID-19. For example, when there were stay-at-home orders out there, if an employee was not employed in a essential job, a critical infrastructure job, such that there was an exception to the stay-at-home order, if they had to stay at home and they weren't able to telework, they were eligible for the paid sick leave. Number 2, if the employee's been advised by a healthcare provider to self-quarantine. Number 3, if the employee experienced COVID-19 symptoms and was seeking a diagnosis, which sounds awful lot like one of the things on the previous slide, but this was simply somebody was coughing and trying to get in to see a doctor, and back in March, April, May of last year, it was almost impossible to get in to see a doctor. Number 4, if the employee was caring for an individual who is subject to a quarantine or was self-quarantining. Number 5, if the employee was caring for a child whose school or place of care was closed, or the child care provider was unavailable because of COVID-19. And remember that number 5 was the reason that you could take, or your employee could take, that expanded family and medical leave. But that was the only reason they could take expanded family or medical leave, which was up to 10 additional weeks on top of the 2 weeks of paid sick leave. And then finally, number 6 was if the employee was experiencing any other substantially similar condition specified by the U.S. Secretary of Health and Human Services. The reason that language was included was not because anybody would actually qualify for leave under number 6 back in March and April of 2020, but rather Congress foresaw that there might be variant strains of COVID-19, and eventually those variations might even lead to the virus being called something else because it's not close enough to COVID-19 to continue calling it that. And sure enough, that looks like it's playing out right now. There are a number of variants of the COVID-19 virus that are out there that everybody's probably heard of in the news. So anyway, long story short, if mutant strains continue to develop and we now call it something other than COVID-19, an employee who experiences those symptoms can likewise take FFCRA. Now, why did I spend all that time going over those reasons? Well, because the clock is now restarted. So an employee who burned up all 10 days of sick leave, paid sick leave last year, gets to reset the clock, meaning the number of paid sick leave hours available, effective April 1st. So an employee who took 10 days last year, if you choose to extend the FFCRA, you can give that employee another 10 days of paid sick leave between April 1st and September 30th and get the tax credit for it. So even if they were out last year, if they now say, hey, I'd like to go get a vaccination, I'm going to take Friday off, or I'm going to take Monday off, and I'll be recovering Tuesday and Wednesday. If you're agreeable to extending the FFCRA, you can get the tax credit for the days that they miss. Now, What's a little complicated here is that the restarting the clock only applies to the emergency paid sick leave, the 10 days. It doesn't appear to apply to extended FMLA. And there is some ambiguity based on the language of the statute, whether somebody who burned up all of their available expanded FMLA last year can now take another up to 12 weeks, which by the way was another one of the additions, was now you can take 12 paid weeks. Previously it was 10 paid weeks, but 2 additional unpaid, which might be covered by the emergency paid sick leave. So there's some question as to whether or not you can get the tax credit if you paid out emergency FMLA leave or expanded FMLA leave last year to the same person that now wants to take it again. And the reason that that's kind of important is because you can now take expanded FMLA leave for any of those now 9 reasons that you can take emergency paid sick leave. Whereas before it was only that one reason, the child, you know, had to take care of the child because their school or daycare or child care provider was unavailable. Now, theoretically, if you have an employee who goes to get a vaccination and has a horrific reaction to it, such that the employee needs to miss work for 12 weeks, you can pay the employee, and be mindful, of course, it's only a percentage, it's not 100% once they're on expanded FMLA, but you can pay that employee and get the tax credit for all 12 weeks, which is certainly a boon to employers who have employees missing work, as well as the employee who's missing that amount of time. So the takeaway, though, that I want everybody to remember is that you may only take advantage of the tax credits if you are in full compliance with the other provisions of the FFCRA. So in other words, once you voluntarily decide that you're going to allow to extend the FFCRA, you need to comply with all of it, meaning you can't discriminate in favor of highly compensated employees. You know, some employers would say, hey, if you're making more than X amount of money per year, we'll go ahead and pay you the paid sick leave so that we can get the tax credits. But no, if you're just out there on the line making 10 bucks an hour, too bad for you. I mean, that's a violation of the FFCRA. You can't pick and choose who this applies to. You can't discriminate in favor of full-time employees, meaning you'll only give the paid sick leave to full-timers, not to part-timers. And likewise, you can't discriminate on the basis of tenure with the company. So, you know, probationary employees don't get paid sick leave. That would be an example of discriminating on the basis of tenure. So the takeaway from all this is if you choose to extend the FFCRA voluntarily, you must have a uniform policy that applies to all employees. You can't pick and choose who would get to take the paid leave there. So any questions on FFCRA before we move on to PPP Round 2? Seeing none, but feel free to type in the chat box. I'm happy to go back. Let me just briefly go into the PPP Round 2. As you know, last year, certain small businesses were eligible for PPP loans, which could be completely forgiven provided that you spent the money the right way. Spending it on salaries for employees, not downsizing your head count, or rent, utilities, etc. Not spending it on the Lamborghini that's pictured here, which, if you've watched the news, you saw that some people spend their PPP money on sports cars, yachts, mansions, etc., and those people are now facing federal charges. So you may be eligible for another round of PPP funding, potentially forgivable loans, if you qualify with the following factors. Number one, if you used your first PPP loan the right way, if you use the full amount only for authorized uses. Now, by the way, I'm not suggesting that if you spend the money on something other than salaries, rent, and utilities, that you've broken the law. No, you could have used that loan money in another way to further your business, but it would not have been forgivable. You would have had to pay the 1% interest rate over, I believe it's now a 5-year payback period. Originally, it was a shorter period than that. That is okay. But remember, if you had to fill out one of those PPP loan forms, you had to make an affirmation that the money was essentially to keep you in business and not for some other personal reason. That's why the Lamborghini gets you in trouble, but spending it on capital improvements for your office, probably not. You know, the consequence of that is likely that you just have to pay back the loan at the 1% rate. But if you did that, you're not qualified for a second draw PPP loan. You must have used the first draw entirely for salaries, rent, utilities. Additionally, the universe of employers eligible for these loans is now smaller. You cannot have more than 300 employees. It's possible that means 300 per site. However, don't quote me on that. Talk to your accountant or your tax lawyer or your bank on that one. If you have more than 300, but they're split up at different locations, it's at least worth the inquiry. But here's the biggie. You must have experienced at least a 25% reduction in gross receipts in any comparable quarter in 2019 and 2020. So if you can show that in 2019, your gross receipts for Q3 were $1 million, but in Q3 2020, it went down to $250,000, then yeah, I mean, your reduction during at least one quarter between 19 and 20 was more than 25%, and you might qualify for an additional round of PPP funding, which again, why would you want to do that? Because it could possibly be completely forgiven, which is a huge boon to employers and businesses in general. All right, any questions on FFCRA or PPP round 2? Hearing none, we will move on into vaccination issues. And the two questions here, can we require them? Can we incentivize employees for getting vaccinated? Well, let me answer the first one. Can an employer require employees to be vaccinated? The answer is yes, with an asterisk or two caveats there. The caveats are you cannot require an employee to be vaccinated if they have a bona fide objection based on a religious belief. Nor can you require an employee to receive a vaccine if they have some sort of disability such that it would not be medically advisable for them to be vaccinated. And I've become more and more aware that there are a number of medical conditions out there, some of them seemingly fairly mild or manageable, that preclude individuals from being vaccinated. And you certainly have the right to obtain some basic information about why it is that an employee can't get a vaccination. However, you don't have an unlimited ability to do so. You have the right to ask them, what is the medical condition that precludes you from getting vaccinated? Can you ask for a doctor's note? That's kind of on the borderline. That's a gray area. I'll tell you, you're potentially skating toward thin ice there, particularly if you look at how other laws such as FFCRA have been adopted, where if a doctor advises an employee to self-quarantine, you can't ask for a doctor's note. You can only ask, who was it that told you to self-quarantine, get the doctor's name, but then you're not even allowed to call the doctor to confirm, much less require a doctor's note. For religious accommodations, you do have the right to ask, what is the religious belief that precludes you from obtaining the vaccination? And you may have heard that there are some religious objections out there. Some of the vaccines have been developed, using stem cells, maybe not recently, but at some point in the linear path during the development of the type of vaccine that the COVID-19 vaccines are. Stem cells were used originally decades ago, and there might be some religious objection there. So if you were to tell an employee, too bad, I don't care what your religious objection is or your disability-related accommodation request is, we're not having anybody who doesn't get the vaccine. Have you broken the law? Well, there's a way to do it correctly and a way to do this incorrectly. The correct way of doing things is to first evaluate whether having an unvaccinated person in the workplace would pose an undue hardship on the company. Because, you know, as you navigate through the Americans with Disabilities Act, the first question is, has the employee requested a reasonable accommodation? Presumably so if they tell you I'm not getting vaccinated. Now you go to number two. Number two, would it be an undue hardship for me to provide this particular accommodation, the accommodation that they're seeking, which is presumably, I don't want to get vaccinated, but I want to continue working. If it would be an undue hardship, for example, because a non-vaccinated person in the workplace would pose a direct threat to the health and safety of others, for example, if you have other high-risk employees in the workplace or family members of employees are high risk, you may very well be able to say, I'm sorry, but you know, accommodating you by letting you continue working would pose a direct threat. That's an undue hardship. We don't have to provide that accommodation. You at that point can legally exclude the employee from the workplace according to the EEOC. And I've actually included the link to the EEOC's page where they go into this issue, just in case you have any questions about what you can and cannot do. The caveat, though, is you can't automatically terminate the employee. So what's the difference between excluding them from the workplace and terminating them? Well, excluding from the workplace is kind of the EEOC's code for place them on an unpaid leave of absence. And for those that have had to deal with unpaid leaves of absence under the ADA, you know that an indefinite leave of absence is not a reasonable accommodation, nor is open-ended leave. What the EEOC doesn't tell us in the context of vaccinations is how long do we need to keep an employee out on unpaid leave before we can just go ahead and terminate them? There's got to be some point in time where it becomes an undue hardship. I predict what the EEOC will tell us at some point is, well, you need to evaluate that on a case-by-case basis. The EEOC is not in the business of providing bright line rules, but rather has told us time and again in its regulations that every situation is different and every situation needs to be evaluated on a case-by-case basis. If you are getting to the point where you're thinking, I really can't have somebody out on this indefinite leave of absence much more, I recommend that you reach out to Myra or you reach out to me so we can go through what the potential risks are and exactly how comfortable you should be letting somebody go once we get to that point. I would say that we're certainly not there yet for anybody. I mean, the vaccines have only been widely available to anybody for less than a month, and I would dare say that the EEOC would not find that affording a month of unpaid leave to be an undue hardship on just about any employer, regardless of the size. So now let's go to the next question. Can an employer incentivize employees to be vaccinated? And to this, I shrug my shoulders like the individual on the slide here. The answer is, it is unclear at the moment whether employers can lawfully incentivize employees to be vaccinated. And I have seen myself in the news instances of large employers offering some pretty significant incentives to employees to get vaccinated, such as paid time off, such as bonuses. I heard of one employer that was offering $2,500 to any employee who was vaccinated. I don't know that that's lawful, and here's why. There's currently no EEOC guidance as to whether you can do this or not. There's no guidance saying you can't do it, but there's no guidance saying that you can. Well, if there's no law that says I can't do it, why would I be worried about it? Well, let me tell you a story. Here's what the EEOC has been struggling with for years. It has for really many, many years, since the dawn of incentivized wellness programs, taken the position that you can't incentivize employees to participate in a wellness program, nor can you disincentivize them, such as some wellness programs actually would, fine employees if they failed to follow the contours of the wellness program. For example, if it was a weight loss program and the employee gained weight while on that program, there was a disincentive, like the employee would have to pay $1 for every pound they gained or something along those lines. Well, the EEOC takes the position that, hey, if you have these types of programs, you are discriminating against employees who have disabilities that preclude them from participating. So maybe the wellness program involved walking 10 laps around the building at lunchtime, and if you did that for 10 weeks, you get a $100 bonus. The EEOC says, well, what about your employees who are in wheelchairs or scooters, or who otherwise physically can't walk around the building 10 times? What are you going to do if you don't provide some way for them to get that $100, the same incentive that everybody else does? You are excluding them from terms and privileges of employment that non-disabled people enjoy. So for the longest time, EEOC says, hey, incentives in connection with wellness programs, unlawful. However, a court in a federal appellate court back in 2018 told the EEOC that a proposed regulation that they were drafting along those lines would not be lawful, and the court tasked the EEOC with coming up with a new proposed regulation. Well, 2018 happened to be the time that the Trump administration was coming into full force, and the EEOC kind of did a 180 here. Maybe not a full 180, but at least a 175 in drafting a proposed regulation that said, hey, wellness programs can offer incentives. Radically different from the EEOC's position for years and years, but only if the value of the incentive was minimal, meaning nothing more than like a water bottle that had the insignia of the employer or the wellness program on it, or the $10 Starbucks gift card. Certainly not the $2,500 that I've heard about in the news recently. After the EEOC enacted that proposed regulation, though, which was in January, before January 20th, inauguration day of Joe Biden gets inaugurated. Very shortly after that, the EEOC withdrew the proposed regulation altogether. So we're kind of left scratching our heads, what does that mean? Does that mean that the EEOC has gone back to its previous position despite the Court of Appeals back in 2018? And by the way, we're in the midst of trying to get back to normal from a pandemic. The U.S. Chamber of Commerce has lobbied the EEOC and Congress to expressly permit employers to incentivize employees to get vaccinated. A vaccination could be treated similarly as a wellness program, right? You're trying to promote the public health of your workforce. And if you incentivize people to get vaccines, we run into the same issues as with the wellness programs. There are some people who can't get vaccinated, and is excluding them lawful or not? So the EEOC, in response to the U.S. Chamber of Commerce, basically said, yeah, we'll get to it when we get to it. Our next steps are under consideration. So we still don't know what the EEOC's position is. The advice that I have given to employers wondering whether to provide incentives is, hey, look, there's nothing on the books right now that says you can't do it. But the way employment law generally works is Congress passes a law or the EEOC issues a regulation, and employers get in trouble for what they've been doing up until that point. So you're running the risk that at some point the EEOC says, hey, you can't do that, sorry, and now you're in trouble, you've paid $2,500 out to everybody. Joe asks, I'm curious what counts as incentives other than cash. For example, is it an incentive if you say people who get vaccinated don't need to wear masks at work? That is a great question. And the answer to that actually has more to do with CDC regulations and local Department of Health guidance as it stands right now than it might once mask mandates are lifted altogether. Let me address masks specifically at this point, but let me then go more broadly into non-cash type incentives. So the incentive of you don't have to wear masks at work, well, the CDC is still saying even if you've been vaccinated, you should wear a mask when you're in close contact with others, such as in an office setting. And as we'll discuss in a moment when we get to Florida's business immunity law, you might be disqualifying yourself from immunity if you were to enact that particular incentive as of right now. Now, in the more general sense, though, it's also problematic potentially if you are providing any incentive whatsoever. And I would say that this specific example, even notwithstanding the CDC issue, again puts you at some level of risk that an employee could say, hey, I can't be vaccinated. I really hate wearing the mask. You're treating me differently. That's discrimination based on my disability or my religious preference. So I do think there's a potential issue there. I think that non-cash actions, I shouldn't say I think, I know, non-cash conduct by the employer counts just as much as an incentive as paying them some token amount of money. Now, granted, under the previous regulation, which I think here, employer can offer incentives only if the value of the incentive is minimal. There's some haziness there as to, well, what about non-cash incentives? Do I need to somehow prove that the non-cash incentive is of minimal cash value? We don't need to worry about that because that regulation was repealed. But my advice is it doesn't matter if you're offering money or some more favorable condition at work, that would still count as an incentive. The takeaway here, and this might also help answer Joe's question, is if you plan to offer an incentive for being vaccinated, you should be prepared to offer an alternative for obtaining the incentive to those who object on religious or disability-based grounds. So for example, and this has come up in the context of the wellness programs, 10 laps around the building, well, tell you what, if you can do something else that's the equivalent of 10 laps that doesn't involve you actually having to walk or run, we'll give you the same $100. The example here is provide an incentive to those employees to take a COVID-19 safety course, or to somehow agree that they will social distance and wear the mask and wash the hands and do everything that the CDC is calling for in order to obtain the incentive. Many employers aren't going to want to do that. They're not going to want to provide an alternative way to get the incentive to get around getting vaccinated. They want to tell employees you need to get vaccinated. And if you are struggling with wanting to or agreeing to incentivize those who don't get vaccinated, but you still want to make sure as many people get vaccinated as possible, you might want to consider a mandatory vaccination there. And then there's, of course, the middle ground, which is to strongly recommend employees get vaccinated, but to neither require it nor to incentivize it. And while that's certainly the safest ground, every workplace is different, and some employers have a greater concern of getting everybody vaccinated than others. If that's not your biggest concern, if it's perfectly okay to have people in masks continually, to have non-vaccinated people in the workplace, and it's not a huge concern of yours, well, fantastic. Maybe the middle ground is the perfect avenue for you because it's the one with the least potential legal risk. All right, before we move on, any other questions on vaccines? Hearing none, let me now talk to you about Florida's COVID-19 business immunity law. This law was signed into, the bill was signed into law on March 29th. It was effective immediately. It provides limited immunity if certain conditions are met. And what I mean by limited immunity is that you need to meet the conditions. If you fail to meet the conditions, you don't get the immunity. But if you meet the conditions, immunity is 100%, meaning there will be no liability on the part of the business. And the types of claims the business immunity law addresses are any claims made against the business that their conduct or their inaction or their negligence led to an injury as a result of somebody contracting COVID-19. So in other words, I went to Myra's general store and nobody was wearing masks and everybody was coughing on me and Myra didn't do anything about it. And I developed COVID-19 a week later. I'm sure that I got it there. And I was so sick, I missed work for a year. I want to sue Myra's general store for my lost wages. Well, up until March 29th, I could proceed with that lawsuit. And granted, I'd have to prove my case, but nonetheless, my lawsuit wouldn't get kicked out of court on day one. Now, with this business immunity law, there's a chance that I could, if I'm Myra's general store, get the case kicked out on day one. Small footnote here, and I know it does apply to some of the folks on the call here, different standards apply to healthcare providers, and healthcare providers is defined quite broadly under the statute. It encompasses not only places where clinical care is given, but also the practitioners themselves who provide clinical care, home care, or any other type of kind of face-to-face care with patients. And I'll get to what those standards are for those that would be covered there. So what I mentioned here is that the business immunity law does not allow a return to the pre-COVID Wild West where nobody's wearing the masks, and as you can see here, they're not really socially distancing at the table, and it kind of looks like we've got a minor drinking draft beer here. So this is not what everybody can do. You must show that you are complying with whatever various guidance is out there by any governmental entity. Now, by the way, even before we get there, the legislature threw in this kind of grenade or landmine for those who are trying to bring lawsuits against private businesses other than healthcare providers, claiming they were injured in connection with exposure to COVID-19 within that business site. The claimant has to submit an affidavit from a physician that within a reasonable degree of medical certainty, the claimant's COVID-related damages, injury, or death occurred as a result of the business's acts or omissions. So it's not enough simply that, hey, my lawyer says, yes, I'm sure that I contracted COVID-19 at Myra's general store. I now need to go get an affidavit from a physician. And I'm not sure too many physicians are going to be willing to provide that type of affidavit. But let's assume that they are, that there are physicians out there who are willing to do that. You still are entitled to business immunity if you have made a good faith effort to substantially comply with authoritative or controlling government-issued health standards or guidance at the time the cause of action accrued. What counts as an authoritative or controlling government-issued health standard or guidance? Does the CDC count? Does the Department of Health count? The answer is yes. Both the definitely the Department of Health, the Florida Department of Health, which has county-level branches in every county. But the CDC is a quasi-governmental entity. So in order to take advantage of the business immunity that's granted by this law, you will need to make a good faith effort to substantially comply with what the CDC's guidance says. Presently, the CDC requires mask wearing, hand washing, social distancing, etc. And for as long as the CDC continues to do that, you will need to follow the CDC's guidance in order to take advantage of the business immunity. If you don't comply with the CDC guidance, then again, I'm free to bring that lawsuit against Myra's general store, provided I've got the physician's affidavit saying yes, with reasonable medical certainty, that's where I caught COVID. And really, you're dealing with the great unknown if you are sued in this type of claim. It is uncertain what an individual might be able to recover. And frankly, I think there would be a difference between an employee suing an employer, where at least you might be able to argue that this is a workers' comp matter, versus a customer who could sue for negligence or punitive damages potentially. And if there's a loss of life involved, let's say, hey, I went to Myra's General Store, caught COVID, gave it to my grandmother died, the sky is potentially the limit on what a jury might award there. So be mindful of what the CDC's guidelines are, and be mindful that they change frequently. Even just last Monday, the CDC came out with guidance that said sanitizing porous surfaces may actually do nothing in terms of coronavirus spread, because COVID-19 doesn't survive on porous surfaces very long, although I believe it's a little different for indoor smooth surfaces. But nonetheless, you may have seen in the news there was a rather salacious quote from one of the directors of the CDC saying that that type of sanitation was mostly merely COVID theater. In other words, just eye dressing to make it look like a surface is more safe than it otherwise would be without the sanitation. For healthcare providers, let me say this: the major difference or differences are that the claimant doesn't need the affidavit from the physician. They don't need an affidavit saying that Dr. Jones is the person who gave me COVID. They can simply proceed with their lawsuit. And also, you, the health provider, would bear the burden of showing that you substantially complied with government-issued health standards or guidance. That's a pretty big difference from the non-healthcare businesses, where you only need to make a good faith effort to substantially comply. You don't have to actually substantially comply, but show that you made a good faith effort. Show that your HR director is monitoring the CDC guidance once a week and that you're following the CDC guidance. You're probably good on that. And hey, oh, by the way, if you are not a healthcare provider, it's not your burden to show the good faith effort. It's the plaintiff's burden to show the business failed to make a good faith effort. And the reason that's significant is because burdens of proof and affirmative defenses are very significant in the courtroom in terms of, whether you might get the case kicked out before it goes to trial, whether you're entitled to some sort of presumption that the other side has to rebut. So this is a big deal for private businesses other than healthcare providers. If you are a healthcare provider, well, you still have a chance of business immunity, but the burden's on you now. And the burden is not just the burden of proof, but it's also to show a higher level of compliance. You need to show substantial compliance, not merely that you made a good faith effort to comply. I see that I have a question pertaining to vaccinations that I missed a minute ago, so let me go back there and I'll read the question from Vanessa. In regards to incentives, does not having to quarantine when you travel count as an incentive? This is for air travel mostly. That is an excellent question, and it is multifaceted in the sense that if somebody is merely traveling, not in connection with getting a vaccination, would that be an incentive? Probably not, because remember, the whole question is whether you're incentivizing people for being vaccinated or for participating in a welfare program. Although I guess maybe your question might be, well, hey, what if they've been vaccinated and then we don't require a quarantine after travel? Would that be considered an incentive? Well, possibly it could, a non-monetary one. So I can see that, yes, maybe in that circumstance. However, in the bigger picture here, you may have a travel policy that says if you are traveling to or from a location that's not on the CDC or State Department's list of hotspots that you shouldn't travel to, you don't have to quarantine. I really don't see a problem with that. That's not connected with being vaccinated in any way. And Vanessa has clarified, yes, she did mean if they're vaccinated. So let me go back to this. Yes, it's likely an incentive. There, however, is not currently a law that prohibits providing incentives. So the risk that you run really is that at some point in the future, the EEOC says providing incentives is not okay. And then your universe of the workforce that had to quarantine following travel might have the ability to file something with the EEOC. And your defense, quite candidly, is, hey, at the time, this wasn't against the law. There was no guidance saying we could not provide incentives. And hey, look at what everybody else is doing here. You know, you can point to a number of employers who are providing incentives. The risk is, do you want to be the test case? Do you want to be the one that the EEOC says, hey, you're doing something wrong? Frankly, and this is me not providing legal advice, but just providing a general observation, I suspect that the EEOC would be more likely to go after big companies who are offering large dollar amounts as incentives than to go after a company that's maybe offering non-monetary and you know, non-monetary and of minimal value type incentives to employees who are vaccinated. And again, we're talking 3 steps down the road, because we're assuming the EEOC at some point will say you can't incentivize vaccinations. They very well might go the other way. There is significant support among the business community, as well as individuals willing to be vaccinated, to allow incentives for vaccination. So who knows? We'll just have to wait and see what the EEOC does there. But I want everybody to be aware it's at least an issue that's out there. All right, well, does anybody else have any COVID-related questions? Because now we'll move on to the non-COVID related employment law updates. Excuse me. I'm seeing none, but feel free to type ahead and I'll come back if anybody does have any questions. The first one, let me remind everybody who has minimum wage or close to minimum wage employees, including tipped employees, that last November, Florida's electorate voted to amend the Constitution to gradually increase the Florida minimum wage up to $15 an hour. And the first increase to minimum wage will take place effective September 30th of this year, and will go up $1 per hour each successive year until 2026. Question is, Maria asked, as for the masks, I wanted to be clear that we should still require employees to wear masks in the workplace, correct? The answer is yes. The CDC is still recommending masks. As a matter of fact, Orange County, where many of you are located, still has a mask mandate in place. Palm Beach County still has a mask mandate in place. Broward, Miami-Dade still have mask mandates in place. In fact, I think just about every county that had a mask mandate still has it in place, although the governor has said he will override any fines that are levied for violations of those mask mandates. Jerry Demings, who's the mayor of Orange County, said earlier this week that he expects the mask mandate might possibly be lifted at the earliest sometime in the late summer. So yes, definitely, until you hear the CDC is now saying mask wearing is not required, I wouldn't even consider revisiting the policy, particularly in light of the Florida business immunity law that says, you know, in order to take advantage, you need to be in compliance with any governmental recommendations. So yes, and thank you, Maria, for that question. At some point, trust me, probably we'll send out an email blast to everybody about mask mandates being lifted and employers being free to not require masks in the workplace. All right, so going back to the Florida minimum wage, this is a pretty self-explanatory one, but because there is a deadline of this year, I just wanted it to be on everybody's minds. If you're in charge of budgets, be mindful that the fourth quarter of 2021 you know, might be impacted if you have minimum wage or tip credit employees. The tip credit will remain at $3.02 per hour. So come September 30th, the tip wage that you would end up paying would be $6.98, up from you know, it's about $1.62 less than that now. So everybody just be mindful. We don't want any minimum wage claims made after September 30th. Florida also passed an E-Verify law, which was effective January 1st of this year. There are requirements pertaining to public employers that are different from those applicable to private employers. Public employers include not just state of Florida, you know, city of Orlando, city of Miami, county, you know, any local governmental unit there, but also contractors and subcontractors. So if you are even a second level contractor with the state or the county or your local city, you count as a public employer under this law. And you must use E-Verify to verify the work authorization status of all newly hired employees. If they came in the door prior to January 1, 2021, you don't yet have to use E-Verify to verify, but any new hires, you must use E-Verify. Not merely check their I-9 status, which you also have to do under federal law, but you must use E-Verify. For private employers, after making an offer of employment and the applicant accepts, you may use either E-Verify or you can simply require the same documentation that's required by U.S. Customs and Immigration Services on an I-9 form. You must, however, maintain copy of that documentation for at least 3 years if you choose to go the I-9 route. And I think many private employers are choosing that route because it's no more work than they otherwise would have to do. But if you want to use E-Verify, you're welcome to do so. In fact, I think the state is encouraging you to do so, possibly as a prelude to, at some point in the not too distant future, the state expanding the requirements not only to public employers, but also to private employers as well, that they'll be required to do that. Some things to be mindful of if you're a private employer and E-Verify is completely foreign to them. There's no minimum number of employees required for the law to apply. This applies to one employee companies, theoretically. There is no requirement that you verify the eligibility of employees hired before January, but here's the big catch. If you have contractors, contract workers, meaning you've got a consultant that you treat as an independent contractor, you give them a 1099 at the end of the year, you have somebody come in for a short job that you give the 1099 to, you must verify upon renewal of their contract or an extension of the contract. So what's kind of ironic is that the universe of people that this affects includes the post-retirement long-time worker for the company who's now on board as a consultant, really not doing a whole lot, but still getting a little compensation from the company. You need to verify that individual's eligibility through E-Verify or the I-9 process the next time that contract is renewed. And I also had a conversation with Myra just the other day about, well, hey, does this apply in the context of volunteer work? And the answer is, well, maybe, particularly if you're paying your employees to go volunteer out somewhere else, with a charity, local nonprofit or something along those lines. That looks really like a contractor relationship in the eyes of the IRS or even various workplace law agencies like the EEOC, rather than a true volunteer who's going there on their own time, no expectation of being paid in any way, shape, or form. So there might be an obligation to be verifying in that circumstance as well. Excuse me. Let us conclude here by talking about the Biden administration looking ahead in 2021 and beyond. And there are a few things that I'd like to cover here. In fact, this is really traditionally what we would cover in non-pandemic years. We would be looking into the crystal ball at the beginning of a new administration to tell you what's out there and what's likely coming on down the pike here. The first thing that I will mention, which was the first thing Myra mentioned, is that we have a new Secretary of Labor. The new Secretary is Marty Walsh. Mr. Walsh was previously the mayor of Boston, as well as a state legislator in Massachusetts. And other than those jobs that he had in the government, the only other jobs that he has had have all been within unions or various union conglomerates, such as trade councils. I believe he was the president of the Laborers Union for many years in Boston. He was also the secretary and the treasurer at various points of a trade commission of the construction services in Massachusetts. So his background is a union-based background. And what does that mean for us? Well, what that means is that in the general sense, you can expect that the Secretary of Labor, and by extension, the various agencies under the Department of Labor, to be more pro-employee. I know that's not earth-shattering news here. You know, anytime there's a Democratic with a capital D administration, that's what you can likely expect. It'll be more of a pro-employee agency than in Republican administration years. But additionally, this is a secretary whose background is with unions, not merely as an employee rights advocate. So we can expect the NLRB, the National Labor Relations Board, to be particularly busy. There are 4 agencies that I'll talk about under the Department of Labor: OSHA, the EEOC, the Wage and Hour Division, and the National Labor Relations Board, where we can expect to see some things in the very near future. And by the way, the reason I'm talking about the agencies as much as I am is because the administration itself, you know, on the executive level, President Biden, Vice President Harris, their agenda thus far has really not been employment law related. It has been more concerning the COVID-19 pandemic and social justice issues. And they've been very visible on those. Whereas for the employment issues, the administration has really deferred to Marty Walsh on those. What we can expect to see from OSHA, and what I think AAG will be talking about next month during their face-to-faces with all of you, will be some upcoming actions by OSHA. You know, be mindful that OSHA has this general safety requirements. Generally speaking, employers are required to provide a safe workplace. OSHA has not to date, however, come out with national COVID-19 protection standards, other than, you know, we are generally left to guess that OSHA would probably side with the CDC. If you're not following the CDC's guidelines, OSHA would say you're not providing a safe workplace to your employees. We expect OSHA to come out with some very specific protection standards in the not too distant future. And certainly I will alert Myra, who will alert everybody else when and if that happens. Also, OSHA's budget appears that it will be increased substantially, and that means additional funds for enforcement, as well as possibly grants for employers, which is definitely something you might consider taking advantage of, just like you may consider taking advantage of the paid sick leave, the paid FMLA leave, which is a dollar-for-dollar reimbursement. I mean, this is money that comes into the company, basically, that you don't have to pay back. So certainly, as those arise, we will keep you posted in case any of them might apply to you. The Equal Employment Opportunity Commission has expressed its priority to be increased LGBTQ protections. And you may have noticed that since the beginning of the year, more and more state legislatures have been passing bills that pertain to transgender rights or the lack thereof, such as transgender sports in high school, such as bathroom bills. Why are we seeing those all of a sudden when we really hadn't seen that in the last 4 years? Well, it's because those state legislatures are anticipating that there will be a reversion back to Obama-era rules and proposals. And toward the end of the Obama administration, those rules and proposals focused on transgender participation in sports and the use of bathrooms by transgender individuals. And just to recap very briefly, those rules required that high schools allow transgender girls to be able to participate in girls' sports, provided certain criteria were met, and transgender boys to participate in boys' sports, really without any criteria. In fact, the Department of Justice was applying those standards to the NCAA back in 2015, 2016. You probably haven't heard too much of that in recent years, but you will. And likewise, the bathroom rules were essentially, if I had to sum it up in one sentence, that you could not simply have a separate bathroom for transgender workers. You would need to allow employees to use the bathroom of the gender with which they identify. So the rules that are being passed by state legislatures are designed to contradict those federal level rules. And of course, federal law overrides state law. Maybe these are mostly for show, maybe not, but that's why you're seeing them. Additionally, last summer, the Supreme Court issued a ruling in a case called Bostock that Title VII prohibited discrimination on the basis of sexual orientation and gender identity. In other words, discrimination on the basis of those two categories is discrimination based on sex, which is prohibited by Title VII. What we will likely see from the EEOC will be more guidance about issues that weren't squarely addressed in the Bostock case. Bostock basically stands for the proposition that you can't fire somebody simply because of their gender identity or their sexual orientation. It did not address more complex issues such as, can you have a health plan that covers hormonal therapy in some instances, but not for gender reassignment? And crystal ball here, EEOC is going to say no, health plans cannot pick and choose when they cover hormonal therapy, but those are the types of things that we'll likely see being rolled out by the EEOC for the next 4 years. The Wage and Hour Division has made its priorities clear as well. The Wage and Hour Division is looking to increase the national minimum wage to $15 an hour. Here in Florida, that's probably not going to affect us unless the timeline for the increase is quicker than the 5-year gradual step-up approach that we have in Florida. If you have tipped employees, let me give you the heads up, the Department of Labor is trying to eliminate the tip credit, meaning you would have to pay the tipped employees whatever the federal minimum wage is at the time rather than the reduced rate that you are likely paying now. The Wage and Hour Division is also likely going to issue standards regarding when you can treat a worker as an independent contractor versus as an employee. And of course, it will be less likely that you'll be able to consider them an independent contractor. The reason the Department of Labor and the Wage and Hour Division wants employees treated as employees or workers treated as employees really has to do with revenues. The IRS makes more money when you treat somebody as an employee because now you're matching the taxes for Social Security, for FICA. Same is true with workers' comp. But also, the Wage and Hour Division, as well as the NLRB, want to make it so that workers have more access to other benefits, such as health insurance through an employer, which would be denied to contractors. And then finally, look to see some clarification on joint employer standards and issues. Joint employment being, for example, if you use a PEO that supplies employees to you and does the payroll and gives you a sample handbook and all of that. Despite what might be said in your contract with that PEO, you're generally a joint employer with the PEO, although maybe not in certain circumstances, such as for Title VII purposes. But if you use a vendor, if you operate a hotel, this is very common. There's a contractor that you call in for housekeepers or for dishwashers, and the hotel would like to think we're not their employer, but really you are. You're a joint employer, and if the staffing company fails to pay minimum wage properly, fails to pay overtime, then you could be on the hook, even though that's not something that you directly do. And finally, the last topic will be the National Labor Relations Act and the National Labor Relations Board. Before I get to the board, let me tell you what's going on at the congressional level. You may or may not have heard of a bill called the PRO Act, the Protecting the Right to Organize Act, which passed the House of Representatives in 2020, but did not pass in the Senate. It also passed in the House last month and is currently before the Senate. Be mindful, the Senate is now 50-50, with the +1 being the vice president. The PRO Act would radically change the National Labor Relations Act, which of course is the law that governs how unions can organize. It governs even non-unionized workplaces in the sense of what you can and cannot have as your workplace policies. Here are some of the highlights of what the PRO Act provides for. It would provide expanded liability for joint employers. Again, this is something the Department of Labor is already working on. It would limit the definition of independent contractors. Sound familiar? We were just talking about this on the last slide. If you don't know this already, under the current law, the National Labor Relations Act, supervisors are not eligible to form a union or be in a union because, generally speaking, employers can only act through their supervisors. Therefore, employers and unions are opposites of each other. Supervisors fall on the line of the employer. What the PRO Act would do is revise the definition of supervisor to make more employees eligible. So if somebody is merely a lead or maybe even an assistant supervisor, depending on their duties, they might now be eligible to form or join a union, whereas previously they would not. The Act would also expand the scope of unlawful labor practices, ULPs, and increase the monetary penalties such that supervisors and executives could be held personally liable for violations of the National Labor Relations Act. The PRO Act would also override state right-to-work laws, which more than half of US states have, including Florida. And if you aren't entirely sure what a right-to-work law is, it simply means that if you wish to work at a unionized employer but not join the union, you don't have to. You don't have to pay union dues, and the collective bargaining agreement's terms actually protect you. So if the minimum floor for hourly compensation negotiated by the union for your position is $15, the employer's got to pay you at least $15, even though you're not in the union, even though you're not paying union dues. Overriding right-to-work laws would mean that the employee has to pay union dues whether they are in the union or not. Doesn't mean they have to join the union, but it does mean they have to pay the union dues. Additionally, the PRO Act would prohibit the company from mandating that employees attend meetings where basically the employer campaigns against the union, which is a very popular tactic, of course, in a union organizing drive. It would require that ballot sites be available away from the workplace. Currently, the ballot sites during a union election are usually right there in the break room, as well as it would require mandatory alternative dispute resolution, such as arbitration or mediation, if there are any impasses when negotiating a first contract. Here's the little secret of becoming unionized. If a union is formed in your workplace, you have an obligation to negotiate in good faith to try to come to a collective bargaining agreement. There's no legal requirement that you actually do come to that first contract, though. This change in the law would lead to a first contract just about 100% of the time, because an arbitrator would decide what the terms of the contract are if you're not agreeable to them. And finally, the PRO Act would prevent an employer from using an employee's immigration status against them when determining terms and conditions of employment. I will tell you that possibly the most significant aspect of this provision is that as of right now, it is not unlawful for an employer to deny employment to somebody, to an applicant, who, if you hired them, would require that you, the employer, sponsor them in their bid to obtain immigration status. There's nothing wrong with that as of right now. The PRO Act, however, could change that, and that's significant. If you are now prohibited from saying no on that basis, you might find yourself in what, as an employer would not be a desirable position, which is becoming a sponsor of an applicant who might become your employee, which could be costly to you. Now, all of those things, by the way, require action by Congress. The NLRB cannot simply mandate these things. Congress has to. But the board can do the following. The board can revisit Trump-era rulings on handbook policies. For the last couple of years, you have not heard me tell you about how seemingly common sense handbook policies were illegal. And the reason for that is because under President Trump, the NLRB was really undoing all the decisions up until that point of the board that determined those policies were unlawful. Now we're going to see a shift back. it's just a question of how quickly those cases are decided by the board and what particular handbook policies the board addresses. But I assure you, we'll probably see more and more of those. And why is it that those handbook policies are illegal in the first place? Brad, if you're still on the line, I hope you're drinking early, buddy, because it's time to take a shot. It's his favorite drinking game. It's anytime Keith Hammond says protected concerted activities, take a drink. Protected concerted activities are protected under Section 7 of the National Labor Relations Act, which provides that employees have the absolute right to engage in those activities for their own protection or mutual benefit. They have the right to talk to each other about their wages. They have, Brad responds, I was waiting. They have the right to talk to each other about wages. They have the right to complain to each other about their supervisor. They have the right to march in en masse to the president's office and demand more benefits. All of those things are protected concerted activities, and handbook policies that tend to chill those activities might be considered unlawful. The good news for everybody is that it takes time for cases to wind their way through the National Labor Relations Board. You probably have a little bit of a buffer before you need to have that handbook reviewed, but that buffer might not be too long. It's difficult to predict. Possibly when we meet again in April 2022, we will have an update on this, and I can tell you whether or not it's time to go ahead with that handbook review to make sure we're in compliance. So we've covered a lot of ground today. I thank you all for your attention. Please, if you have any questions, Myra and I can keep this window open for a few minutes after we conclude here so that you can do so. But let me thank you very much again and thank Myra for having me. And I'm going to try to turn the screen back over to her at this point.
All right, well, thanks everyone for attending. Thanks, Keith, for a great presentation. We'll send a link to the recording to all of those who participated. If you need your credits for SHRM, be sure to let us know. This seminar counted for 2 hours. Have a great week, and thanks again, everybody, for attending.